much of this, I mean, the fact that we're sitting here, we're not even talking about the merits of the case anymore. We are sitting here talking about what do we need to do to get to the start line so they can
Yeah,
begin actually arguing this case. And it seems to me it's feeling like a lot of smoke and mirrors, for lack of a better term, because we were getting so close to the Franks hearing. We were getting so close to taking a look at maybe there was some shady things going on here in Delphi, which we know that the law enforcement and the judicial system very, very closely connected. So I would imagine if you're sitting there going, we don't want all this attention over here, let's go over here and do all of this. It's going to cause chaos for the next several months or years. But
right.
when we're sitting here talking about all of this, we're not talking about all of that anymore, which we had been dealing with for quite some time with Liggett and everything else, and now Gull's in that mix. It just seems to be just far too convenient to have made a move like this than it just to be naturally progressing that way.
I agree. I think we've touched upon this several times, and it's like the timing of everything is awfully convenient.
Hmm.
To go exactly to what you were saying. I mean, what did we quit talking about as soon as the leak in this attack on his attorneys, like, came to be?
Hmm.
We quit talking about the Franks hearing. We quit talking about Odinism. We quit talking about the memo.
Yeah.
All the things that were pending that all of us were chomping at the bit to have this stuff heard. Now it's vanished into
Yeah.
thin air, with the possibility that new council doesn't even have to adopt it.
Hmm.
So when you couple that with the fact that we now know, based on that transcript from the hearing dropping, that not only were they ready to go on the Franks hearing and the ballistics, the motion eliminated that they filed to keep the ballistics or the tool markings out of evidence, meaning the shell casing, um, but that they were ready to go to trial on January 8th, which completely blew my mind. I mean, you can go through all my content and as a practicing attorney for 2 decades plus, there was no way in hell that I thought that they were gonna be ready to go just because there was so much left to be done.
Yeah.
And I'm talking like, because I tell people all the time on my podcast, I'm like, "Look, the pretrial in a case like this is where the war is fought. Everything that is sought to be introduced into evidence by the state is fought by the defense. Everything that the defense is trying to put in is going to be fought by the state. And you've got your motions to suppress, you've got your motions to quash, all these things, because ultimately, like I'm saying, that battle that takes place, both sides are looking for rulings from the judge wherein the judge is saying, okay, I'm going to allow this evidence to come in at trial.
Hmm.
So you're setting the stage for trial with all your pretrial motions, because those things are figured out way beforehand during this period of time in any trial, not
Hmm.
just this trial, but as to what is going to be allowed in evidence.
Hmm.
So like I tell people, if you're really interested in the criminal justice system, if you're really interested in trial work, you have to be like paying attention during all the pretrial phases, because that's the evidence that sometimes if you're just watching trials, you have no idea what wasn't allowed in
Sure.
as evidence, and sometimes it's absolute smoking gun evidence that's kept out for various reasons. So, that battle that's been going on, and when these two lawyers said, look, they told the judge, and we saw it in that hearing that they had mentioned to her, we're ready to go on the 8th. I think that put Gull in a state of utter shock and terror.
Hmm.
Like, I don't think that she was ready, knowing, and we know for a fact because she said on the record that she had not finished even reading the memo, and she had not even begun to look at the 1,500 plus exhibits that were attached to the memo. That in and of itself speaks volumes
Yeah.
about the judge's preparedness in this trial. It also speaks volumes with the fact that McClellan finally brought on co-counsel, in terms of, I think he introduced him, this attorney Luttrell, on the 19th, and then Luttrell enters appearance on the 31st of October. And I had been saying all along, like a case like this, the state has to have somebody else. They got to have a partner on this thing. One attorney can't handle a case with this much evidence and this much to do because it's just too much. So those two things, in light of the fact that 2 months in terms of preparation time for a trial like this goes in the blink of an eye. I mean, look at it. I mean, we're in December,
Mhm.
man, right now.
Yeah.
And so that means that this trial would have been starting in like 34 days,
Yeah. Yeah.
you know, and it's like, my honest opinion, and I have no proof of it whatsoever other than my common sense and my 20 years of experience in trying cases, is that that was the real reason that Gull wanted these guys off the case, because this thing because if they would made the speedy trial demand, that date is in stone.
Mhm.
I can't remember if we talked about this on
Yeah.
our
Yeah.
last
We have.
the last time we got together, but it bears repeating, because that in stone date, if that trial doesn't start on January 8th, the case is dismissed.
Yeah.
There is no way around it. I mean, there's very limited circumstances in which the defendant's right to a speedy trial is going to be paused.
Yeah.
And and the end result of everything that has happened, the biggest benefit to both the state and Gull was that these new guys, the first thing that they did was ask for more time
Mhm.
to continue the trial, which now, as we know, has been continued to October of next year. And that doesn't mean it's going on that date either.
Yeah.
So,
At the
I
end, I
mean, to
mean,
me, when you think about that
yeah. It,
long and hard, and,
it,
just think about the reality of it.
yeah. At the end,
uh,
when we look at all, I mean, is this really just a case of someone trying to cover up a lot of incompetence, a lot of neglect to what they should have been doing, getting ready for this, or is it conspiracy? Because the two can certainly look pretty damn close.
they can, they can,
Yeah.
and I'm certainly not going to sit here and say that Gull was conspiring with anybody, because
Mhm.
that would
Sure.
be reckless, and I
Yeah.
would never do that.
No.
However, I do think that I am more than willing to say that I think that in terms of her ability to be able to get everything that needed to be heard, that was going to be required to be heard in order for this case to be ready for trial, that would have required her to work over the holidays.
Mhm.
And as we found out, she wasn't feeling well, uh, and was hospitalized.
Yeah.
I think that ultimately, in the back of her mind, that she used this gross negligence and the leak as an excuse to get these guys off the case. I really do. And and do I think that she was in cahoots with anybody? No.
No.
I just think that in her mind, that she was extremely concerned about the
Yeah.
preparedness and readiness for this case on January 8th, assuming that these two lawyers were not, just running a move.
Mhm.
I mean, there's plenty of cases where strategically defense attorneys will make a speedy demand in order to try to force hands. I think that these guys, I don't think this was that. I believe that they were absolutely ready to go to trial. And the problem for the state is if they're not ready. And that's why I was bringing up the fact that just at the end of October is they brought in another competent attorney to help McClelland with preparing for the case. That tells you that he was nowhere near being ready for this thing,
Yeah.
and it's not going to matter. As soon as that gavel hits the bench on January 8th, McClelland had to be ready to go.
Mhm.
And if that meant that he was going to put on an awful case because he just didn't have the time to prepare for it, I mean, so be it.
Yeah.
So like all of those things are like looming, and the proposition of that is terrifying. And I think that it's something that has to really be taken into consideration, because it is 100% a factor. I guarantee it.
So for now, are we waiting to hear the response back from the Indiana Supreme Court as to what
That's
happens?
it. That's it.
Do we know
It-
when they're going to make a ruling on that?
I've heard various uh little birdies say, few weeks.
Mhm.
I mean, the fact of the matter is the Supreme Court of Indiana knows all the eyes of the world are on this case. They know
Mhm.
uh, that Richard Allen's Sixth Amendment right in terms of his choice of counsel and also his right to a speedy trial. His right to a speedy trial was just obliterated.
Yeah.
Like that like they're like eh, short of, I think in a perfect world, because defense counsel is asking for three things: one, that they're reappointed; two, that Gull is removed; and three, that they get a 70-day date
Yeah.
um, for the thing to go to trial. And like, I don't know that the Supreme Court would give them the 70-day. I
Mhm.
think that the Supreme Court, if they get to the merits, uh, very likely will reinstate them and pull Gull from the case.
Mhm.
Because that question of whether or not she's biased,
Yeah.
it's an interesting question. She vehemently denies it. But then when you look at her words and you look at her actions, they'll speak to a different scenario. I mean, to me, because I have it out with my wife a little bit, and I say that tongue in cheek, but like that period of time on the 19th when Baldwin and Rosie asked for Alan to come back in chambers so he could be made a party and be made aware and be given notice that she was effectively removing his attorneys.
Mhm.
And she's like, there's no way. Like I'm not comfortable with him in my chambers,
Yeah.
even though, obviously he'd have massively armed law enforcement guys like flanking him and he's shackled.
Yeah.
Her saying like it just kind of goes in, and I give it to Allison, I'm like, well, I could see a judge saying that,
Mhm.
it's not common for the defendant to be brought into chambers. It's rather uncommon. But this whole situation is
The whole thing's
uncommon. So
uncommon. Yeah.
in terms of, should that have happened? Maybe, maybe not, but what it does is it does give you a glimpse into her psyche about what she thinks about Richard Allen.
Yeah, very much so.
Like I'm not getting that, oh, she's presuming he's innocent. I'm getting that, well, she thinks that he's a child killer and
Mhm.
she doesn't want him anywhere near her,
Yeah.
especially in her chamber. So, whether or not that reaches to the level of bias, maybe, but in terms of what I think is the bigger question in terms of bias is the things that she's just outright, flat out said about Baldwin and Rosie.
Yeah.
I mean, she's flat out just said, "I think you're incompetent.
Mhm.
I think that you're liars." She said those things on the record, and, moving forward, if they're reappointed to the case, how do you keep that judge on there?
No, exactly.
When she said that, I mean, like that will instill zero confidence in the judiciary from the public, because you're just going to assume every time the defense loses a motion that they've brought, it's because she hates them and she
Mhm.
thinks they're incompetent.
Sure.
But whether it's true or not, it's like
Whether it's true
some
or not,
things are just for
the
appearance sake,
the optics just for the sake of the case and the sake of
Exactly.
transparency, why not just look, too much stuff happened here, intentional, not intentional, whatever. Wash our hands of it.
Exactly.
Let's start this in a fresh way, and then everyone can move forward. But we just
Exactly.
kind of get caught up in
Exactly.
this infighting. Well, out of their three requests in there, as Meatloaf said, 2 out of 3 ain't bad. So we'll see what
2 out of 3 ain't
we'll
bad,
see what
man.
the
Like those
Supreme
those
Court
2 out of
says.
3. And I think, like, what they would end up doing, and it would become a calculation problem in terms of the speedy trial demand, is if they get reappointed, I think that they would make the demand immediately.
Mhm.
And, because, like, that factor in which why Gull granted the motion to continue the trial was that the new guys were brand new to the
Yeah,
case. They had to dig into everything. So that issue is removed.
yeah,
And now you've got the guys who've been preparing for a year, a
yeah,
thousand hours of prep time, and they're ready. They're ready to go.
yeah.
So, the new judge, if it is a new judge, is going to have to abide by the speedy trial, and the
Mhm.
thing's going to get set way sooner, which ultimately is a benefit to the family,
Yeah,
of the girls. Both families, I think, want to see justice done. And if that means that this goes to trial, and no matter what the result is, I mean, if they don't have the case, they don't have the case.
yeah,
And the family deserves to know that, because right now, both families are in a position that they are completely relying on and have faith in what law
yeah.
enforcement and the state has told them, and they deserve to know, because it's like, eh, you have to know that they're seeing and reading and hearing the exact same things that the rest of us are. And that can't be, I would imagine, if God forbid I was in that same position, man, I would be mortified right now. I'd be like, what is going on with this case?
Mhm.
It's like if they're watching any of my lives, which is not beyond the scope of reason that they're watching, because I'm talking about this thing all the time
Yeah.
on my YouTube channel. And I'm bringing up valid points, and I'm not coming off like some half-cocked,
No.
tinfoil hat wearing loon. I'm talking about the procedural side of it. I haven't even gotten to, like you said earlier, like
Yeah.
we're not even talking about the
No.
underlying facts at this
No.
point. We're not even close to that. But when the memo comes out, and if they have an understanding that this is the defense making this stuff up, like this, everything that they got from the discovery that was tendered to them from the state. It's like this weird concept that people just think that the defense attorneys are making things up out of whole cloth is
No.
bizarre
Yeah.
and just completely incorrect.
Yeah.
Now, is it their interpretation of the evidence? Of course it is. Just like it's the state's interpretation of the evidence in terms of what was in the PCA, and that's all it is.
Yeah.
Like, that's why I'm always saying, like, you have to have trials in this case for that very reason, because what you have is the state's theory, and it's nothing more than that, because Tony Liggett, Doug Carter, Nick McClelland were not there at the time that the crime occurred. And you know who else wasn't there? Was Rosie and Baldwin. They weren't there either. And maybe Richard Allen.
Yeah.
So the fact of the matter is that all this evidence has to be vetted at trial. It has to be like cross-examinations have to take place, and all of that stuff has to happen. And then only then can we then judge whether or not the evidence is good, and if it's strong enough for the state to meet its burden beyond a reasonable doubt. And until that time, we're all just screaming into the void. It's like everybody bickering and
Yeah.
arguing about this thing online. It's pointless.
Yeah.
Until we get to trial, none of us know. And but some people enjoy the exercise, and I appreciate that. I personally love seeing people do what I do for a living, except on social media and without quite as much knowledge about how the law actually operates. But just
Yeah.
kind of like arguing their case.
Yeah.
I mean, it's kind of like a mini lawyering type deal,
Yeah.
and it's interesting as long as it stays civil.
Yeah.
And it's gotten to the point where it's gotten uncivil in a lot of different places, and there's a lot of shade being cast back and forth between people, and it's like, and I just try to stay above that, because I have no interest in that, and at this point, just doing what you and I do. We just right now we're talking about what matters, and it's the procedural side of it. Like I don't know that you and I have talked about the underlying facts at all.
Well, we did a while ago, but not for the last couple of months. So
Right,
we will see
exactly.
where this lands on our next conversation, because it's always different. Hey, it's Tony Brueski. If you want more of our interview with our guests, be sure to check out our podcast, Hidden Killers with Tony Brueski. Just search that wherever you download podcasts and press subscribe. Also, you can check out our YouTube channel for the full video version of the interviews as well, under the same name, Hidden Killers with Tony Brueski. Check it out, subscribe, binge, and enjoy. Thanks for watching.